Dear audience, my name is Tetiana Antsupova and I am senior researcher at the British Institute of International and Comparative Law and the leading researcher of the project The Dynamics of the Judiciary in Ukraine in the context of the rule of law and the European Union Accession Aspirations. Within our project, we interview current and former prominent national and international judges on the topics connected to the research. And today, on 20th of February 2025, I am delighted to introduce my guest, Lord David Neuberger, Baron Neuberger of Abbotsbury. The audience knows Lord Neuberger as a distinguished British lawyer with an unconventional journey to the highest ranks of the judiciary. He holds the distinction of being the youngest sitting law lord when appointed in 2007. Despite his prestigious judicial career, he maintains a refreshingly humble and often self-deprecating sense of humor, which makes him even more requested interlocutor. And it's always a pleasure to have a conversation with you, David.
Thank you.
Lord Neuberger.
Nice to talk to you too.
Thank you. Lord Neuberger's path to law was anything but traditional. He began with a chemistry degree from Oxford and worked as a merchant banker before discovering his true calling and transitioning to law at age 25. A testament of his character is how he recalls his early days as a judge, feeling like a schoolchild mixing with head teachers when sitting alongside with titans he once appeared before as a junior barrister. And after retiring, Lord Neuberger continued contributing to the legal field as an arbitrator and non-permanent judge of the Hong Kong Court of Final Appeal and international judge at the Singapore International Commercial Court. Lord Neuberger has been committed to the judiciary system in Ukraine as well, which we much appreciate. And he chaired the International Advisory Board, which provided invaluable feedback and comments during the preparation of the final recommendations and the roadmap for establishing and operating the new IP court in Ukraine. He was involved in task force on accountability for crimes committed in Ukraine, which was established in March 2022 after the full-scale invasion of Russia. And I would like to highlight and express my gratitude for joining us pro bono to advisory board of our project, which composed of prominent current and former national and international judges. To conclude my introduction, I want to say that it is a truly honor for me as a lawyer and former judge to have an opportunity to interview you, and also appreciate you allowing me to address you by your first name, David. There isn't a single question, to tell you the truth, I wouldn't want to ask you. However, by today's conversation, I would like us to contribute to the discussion on trust and confidence in the judiciary in Ukraine and beyond, which I suggest to start from your personal experience and reflections on your professional background. You served as a Lord of Appeal in Ordinary until the judicial functions of the House of Lords were transferred to the new Supreme Court in 2009. Considering the European standards of judicial independence, where the separation of powers must be evident and persuasive, the British approach differs significantly, I would say, from the continental European model, so to speak. But nonetheless, the judiciary in the UK is the most trusted among state institutions, which, with nearly 2/3 of the population expressing their trust. I would say in Ukraine, the figures are almost opposite. The vast majority of population do not express trust and confidence in the judiciary. So during your judicial career and being a judge and the president of the Supreme Court of the United Kingdom. Have you ever faced challenges in this context? Or what was the most challenging times and maybe the most significant achievements?
I suppose, in a sense, your question could be said to have two components. One is the oddity of the British system. And I think the oddity is fundamentally attributable to the fact that, perhaps largely because we are an island, this is an island, the United Kingdom over the past 300 years hasn't had any invasion, hasn't had any revolution, hasn't had any tyranny, unlike virtually every country in Europe. And unlike the United States, Italy, and Germany, and many other countries, we're not a new country. And what happened in most countries until the late 18th century was that their constitutions developed in a somewhat haphazard way. And most other countries, because they're new or because they had a big change due to invasion and so on, started to adopt constitutions, which, as I say, really only came into existence in the late 18th century, although there were some before. And the United Kingdom has never had a constitution. And so everything has developed in a haphazard way. And as a result, as you rightly say, until very recently, the top court, the law lords, were part of the House of Lords, which was part of the legislature. And what that meant was not that members of the House of Lords were able to try cases, appeals, although that did happen in the 19th century. What it means is that the top judges get promoted from the Court of Appeal, the first appeal tier, or the equivalent in Scotland and Northern Ireland, to the top court, which is in the House of Lords. So you had 12 members of the House of Lords who were peers, like I was, because they were in the top court, and they spent their time sitting in court. They were technically a committee of the House of Lords. They weren't even a court. And because that had happened for a long time, at least a century, and in many ways longer, nobody thought it was odd. But as you rightly say, once you start having a constitution and having separation of powers, which curiously, according to Montesquieu, started in the United Kingdom, it did seem odd. And finally, in 2009, the top court moved out of the House of Lords and became a separate Supreme Court. But and another oddity was that the Lord Chancellor, who was a political appointment, who sat in the cabinet, was also a judge and could sit and presided in the top court as a law lord in cases. And that was seen to be unacceptable, so that stopped as well in 2009. That brings me to the second point you make, which is confidence in the judiciary. I think that whatever structures you have, it's not enough merely to have good structures, to have good regulations. You only have to look at countries which develop tyrannies or are tyrannies. They may have perfectly good-looking constitutions, but if one or two unprincipled, very strong people decide to go against the constitution, decide simply to override it, then if they don't have serious opposition through the army or the police or publicly, they just override the constitution. So you can have lovely constitutions, but it doesn't mean you have a good system. And similarly, you can have a rather odd system like we had in the UK, and to some extent still do, and have nonetheless a judicial system, and indeed other systems, in which people have confidence. And in the end, having thought about this after you sent me a summary of what you might be asking me. I think the most important thing is to have the right culture. I mean, we all know that in lots of countries, judges, not all of them, but some judges can be bribed. And in some countries, it's very common. I would hesitate to say that there isn't a single judge who could bribe in the United Kingdom, but I think it's quite possible that there is not a single judge you could bribe. And the reason is that it's just part of the culture. I mean, I've asked sometimes by people when I was a judge whether I'd been offered a bribe and what I'd do if I was offered a bribe. And I thought I wouldn't so much be shocked as I would think it was a joke. It just is not on the radar. It's not something that could happen. And I think that with our current obsession with regulations and rules and so on, we are at risk of overlooking the overriding importance of a good culture. The fact that you are thinking about the institution, you're not necessarily consciously thinking about it, but you are a member of an institution which you're proud to be a member of, which has very high standards, and you just aren't going to let down yourself or your colleagues or the system by doing something that's wrong. And if you can introduce that into a system, you've got what I think is the most important aspect of a system that's going to maintain high standards and consequently be respected. I don't think UK judges are better people than judges in many other countries. They're just lucky enough to have become members of an institution which, through normal factors that have effect in mankind, accidents of history, happens to have particularly high standards that it's maintained and therefore has high respect. We're not perfect, and nobody would suggest that we are, but we do have these high standards that so far we've managed to maintain. I think another factor which is more subtle as to why perhaps it's a bit easier for judges in this country is the fact that we haven't got a constitution, and therefore the judges' powers are much more restrained in terms of policy and government actions than in other countries. So we don't have a constitution, so it isn't open to the courts in this country to say that an act of parliament, that a statute passed by parliament, is in any respect unlawful or inconsistent with the constitution. If parliament passes a statute, that is the law. And instead of having a constitution which is above everything, we in the end have parliamentary sovereignty, which is above everything. And if parliament decides something is the law, that's that. Now, judges undoubtedly have power to control ministers when they're acting as the executive and other parts of the executive, local authorities and regulators and other people. They're there, the courts have power, but they have very limited political power. Now, the best example I know is of the contrary is the United States, where the Supreme Court has significant political power. And why I mention this is because where judges have significant political power, it seems to me almost inevitable that the politicians get involved with appointments to the court. And when they get involved in appointments to the court becomes political. And you see that particularly recently in the United States, not taking sides as to who's right or wrong. I just think it's what happened. Whereas in this country, because the judges' political powers are pretty limited, politicians simply don't get involved. And when there is the odd constitutional case, there sometimes is a call from one or two people who don't like the decision the court has reached, that politicians should be more involved in appointing judges, particularly to the top court. But that has never got any traction, and I hope it never does. That brings me to your specific point, which is the most challenging cases I've had. I think that in a sense, I've had a lot of difficult cases because the law throws up difficult problems. And when you're in the Court of Appeal and even more in the Supreme Court, you get the particularly difficult decisions. But I think the case that I had, that in terms of political effect, was a case in 2017, 2016, 2017, following the Brexit referendum, when the government wanted to serve a notice under Article 50 of the Lisbon Treaty, saying that the United Kingdom was going to leave the EU. And a redoubtable character, Mrs. Miller, brought proceedings as an interested citizen for a determination by the courts that the government couldn't do that without formal approval by Parliament. And while that was a technical constitutional question, and as I've said, it's unusual to have fundamental constitutional points in courts in the UK because we don't have a formal constitution, it was seen in the very feverish political times as being a bid to try and stop Brexit. And therefore, the court's decision as to whether the government had to go to Parliament and get a formal statute to approve leaving the EU was seen by the newspapers as a heavily political issue rather than a constitutional issue. And because most newspapers were very committed one way or the other to leaving or staying in the EU, the judges were very much under focus, attention. And that was a time of pressure. And I think the system, not just the judges, but the whole system stood up well. The courts decided that the government did have to go to Parliament to get formal approval. And in the Supreme Court, it was decided by 8 votes to 3. And the government then did what the court said they should do. They went to Parliament. 1 or 2 newspapers who were fervently in favour of leaving the EU produced some very inappropriate headlines referring to the judges who decided the case first before it got to the Supreme Court, the judges who decided the case the same way as we did, referring to them in headlines as the enemies of the people, with photographs of them heavily printed on the front page. I think, although lots of people were shocked and thought the press was badly behaved and so on, and rightly thought that, to me it brought home a slightly different point, which was that in my 20 years as being a judge, I'd never come across anything like this in the press. And I've never come across anything like that since. And the very fact that people were so shocked by it was, in a sense, a sign of how unusual it was, and picking up your point, how respected the judges generally are, so that even if the press doesn't like their decisions, it doesn't get too unpleasant, other than and inappropriately unpleasant, with the exception of this occasion. I think that one has to be careful when one talks, as I do, about the status of the judges. I'm no longer a judge in this country, but I would have said this when I was, and I think a number of present judges would say it. One has to be very careful about not becoming complacent. If things are going well, it can be said there's only one way to go, and that's downwards, and you have to be careful to maintain the respect and the high standards which the judiciary enjoy. And I think that in a fast-changing world, domestically, internationally, and technologically, and indeed socially, you very much have to keep your eye on what's going on and what's changing in order to ensure that you maintain the high standards. I also think that if you are respected and you think you're doing an important job, you do also have the responsibility to carry on doing it properly. So it's a very long answer to your question. I'm sorry.
Oh, I do appreciate very long answer. And I had such a pleasure to listen to you, David, as as well as our audience, I'm sure. And thank you for highlighting such an important point as a core issue, maybe corruption, as you said at the beginning, in building the confidence in judiciary. And it is important to have respect, mutual respect, and balance of powers in between state powers, of course.
I think it's a very important point that I didn't make, and you're absolutely right. Respect between different parts of the government is very important. Um, in this country, the judges do not and should not get involved with what goes on in the House of Commons or House of Lords. That's a matter for the legislature, and the courts should not be getting involved. For instance, when Mr. Johnson, the Prime Minister, was accused of inappropriate behaviour in a number of respects, including in the House of Commons, very sensibly, the House of Commons set up its own committee of members of Parliament to decide what should be done. It was not given to the judges because it was nothing to do with the judges. And that is the way, in my view, that things should be handled. The judges should keep out of Parliament. In the same way, we expect as judges that the politicians will keep out of the decisions that appropriately those for the judges. The government, of course, is frequently involved in litigation in court, not Parliament, but ministers. And sometimes they don't get the result they like. And while they can say they disagree with the result and they can appeal it, it is quite inappropriate for politicians to badmouth the judges, to personalize or criticize the judges. From time to time, the odd minister does that. But again, to be fair, generally the politicians respect the decisions of the court, and even if they disagree with them, they will comply with them. And I think we are in a good place there. And similarly, the government generally, the executive, the enormous executive with all its powers and personnel, do what the judges say when the judges reach a decision that something should be done by the executive or something should not have been done by the executive. But I think when judges decide cases about what the government should have done or what the executive should have done or didn't do, I think it's important that judges bear in mind that they're not the decision makers. The ultimate decision makers are the executive, and the judges have to be careful to respect their primary decision-making function and respect the fact that a number of decisions the government has to make are very difficult, and respect the fact that a number of decisions the government makes is on the basis of an expertise, financial or knowledge of the Secret Service and so on, which the judges simply don't have. So mutual respect, I entirely agree, is vital between the different parts of government.
Absolutely. And as you mentioned, mass media can put judges under pressure, and there are many other challenges which can be faced by judges. And turning our discussion to challenges and establishing trust in Ukrainian judiciary, I would like to to say that it appears that Ukraine is at the same time facing two battles, one of the front line and the other in striving for European Union membership through reforms and different changes, demonstrating its commitment to pan-European values. And Ukraine needs to balance the need for rapid judicial and other reforms with maintaining democratic stability and the rule of law. So this challenge seems to be huge. And theoretically speaking, in your opinion, is it possible to maintain democracy and the rule of law during times of war and times of emergency?
I think, first of all, I've got to say that I've been lucky enough to live in a country where that issue has not really been tested, and therefore I can't speak with great authority, and I can't speak with any direct experience. I think that what history suggests is that undoubtedly, as usual, there have to be compromises. To say that the rule of law and democracy should carry on in a country which is fighting for survival or being invaded, just as if things were peaceful and nothing was happening, is completely unrealistic. On the other hand, to say that you should just forget about democracy and the rule of law if you're fighting for survival or invaded is too far the other way. I think, as usual, there's no question of extreme principle either way. As usual, it's a question of balance, compromise, if you like.
Mhm.
You have to accept that some aspects of democracy, some aspects of the rule of law have to be abandoned or changed in order to meet circumstances. Because in the end, democracy and the rule of law are ultimately practical matters, not theoretical. Or if they are, of course, they have a hypothetical component, but in the end, they're only important because of the effect they have on people's lives. And therefore, ultimately, although, of course, there are all sorts of theories and principles, ultimately, it's a question of practicality. And it may well be, for instance, as happened in this country in the Second World War, as I think has happened in Ukraine, you put off elections because you don't want them during a war. That would be understandable. It doesn't stop you being a democracy, but it's a simple example of changing the rules. In terms of the rule of law, you have to accept that the government should have more coercive powers, more control over freedom of expression during wartime than during peace. But that doesn't mean that you simply get rid of all aspects of democracy or all aspects of human rights. You just have to be pragmatic and to state precisely which principles should go and which principles should be abandoned is, I think, rather difficult because so much depends on the specific circumstances of the particular case.
Yes, absolutely. And I think what is important is for decision makers, for the government, is to proper justify every single decision, every single restriction, because at the moment, if I'm not mistaken, there are 11 articles of the Constitution of Ukraine which are restricted in a certain way of execution your rights and freedoms, like you mentioned, freedom of speech or freedom of movement. But every single restriction, I think, should be proper justified. And the European Court of Human Rights actually has all these different tests how to explain the restriction, how to justify the restriction. So it should be a very intense and difficult decision making, actually. And considering that we are moving, and it is our choice to move towards the European Union and European Union legal system, as you're aware, and reflecting on the outcomes of the judicial reforms since 2014, after the Revolution of Dignity, we aimed aligning Ukraine's judiciary with European standards, but failing to fully restore trust. And we still have this issue with untrusted judiciary. What do you think, in your opinion, what is Ukraine still missing? What we are not doing correctly, what we are not understanding, if we still can't restore or improve trust in the judiciary after so many reforms?
I think it's a difficult question to answer. I think that once an individual or an institution has got a reputation for being dishonest or corrupt,
Mhm.
it's very difficult to retrieve the situation. That's why I'm so anxious that the judiciary in the UK maintains its reputation and maintains its high standards, because it is such a valuable thing, not merely for itself, but so difficult to get back if you lose it. And that's not to say, of course, you can't get it back. The judiciary in this country was not particularly honest or effective in the 18th century. There were good judges, of course, but generally speaking, particularly at the lower levels, it was not very good. And it's got a good reputation now. Not perfect, but good. I think, I'm afraid, in a way, the most important answer is to maintain high standards if you've got them, and simply let time do its job of getting the message across. It may be, and I'm not sure about this, but it may be that constantly changing rules to try and improve things can be counterproductive for two reasons. One is the sign is to the public, things aren't working, that's why we're changing, which is not a good message. On the other hand, if the public thinks things aren't working, then that's not too much of a problem. But secondly, I've observed in the government in this country from outside, talking about the executive, and even in the judiciary from inside, substantial changes can be very bad for morale. If you're working in an institution which is working reasonably well, and there are enormous changes, A, it makes people uncomfortable, and B, everything gets into turmoil for a bit because you're trying to absorb the new rules and the new regulations. People don't know where they are, mistakes get made, confidence is lost internally and externally. So I think one has to be careful about changing the rules. Undoubtedly, it's a good thing to do in some circumstances, but on the whole, I would say, look very carefully to ask yourself whether the problem is to do with culture, to do with the people who are there, to do with the need for more time, or is it really to do with a need for the change in the rules? If it is a need for a change in the rules, then I would say that one should try and keep the changes to a minimum. I've always tended to prefer small technical changes, which are not discombobulating to people, rather than big changes. Because the other thing about change, and particularly big change, is that it can lead to unexpected consequences, sometimes quite bad consequences. So I'm not saying never make big changes. Of course, sometimes it's the only thing to do or the right thing to do. But I think one has to be, like what you said about changing or reducing fundamental rights in times of war. You have to be very careful in setting out why you're making a change and why it's necessary before you make a change. But as I say, the most important thing in my view is to introduce the right culture, which is easy to say. And once you've done it, it's quite frustrating, because if things were bad before, the change in culture won't change the reputation immediately, and it may take some time.
You're absolutely right. The judicial system needs stability, and the country as such needs stability.
Stability is a very good word. I didn't say it, but you're right. That's exactly right.
Yes,
Sorry.
and then yeah, it's okay. But only then the capacity building is possible, I think, on the background of stability, and that's what we don't have. And unfortunately, all these changes, they are very much connected to the political intentions, and even the Venice Commission once underlined that the election of every new president of Ukraine would change the judiciary somehow, which is not positive at all. And consider
It's not positive because it politicizes the judiciary in the public eye. Um,
and
and
it doesn't bring any trust at all. All the changes and even the new faces are not actually changing for better the attitude of civil society, despite it was a request of civil society after the Revolution of Dignity to bring to responsibility, so to speak, Maidan judges after the revolution, who detained many of Protestants, the members of protest. So yes, it was a request of the society, but after we didn't stop for a minute, I think, having all these improvements all the time. And
No.
yeah.
Yeah, please.
Yes, just I was going to ask another question about possible solutions and strategies for restoring confidence, because one of the innovations of the comprehensive judicial reform after the Revolution of Dignity, as I said, after 2014-16, it was qualification tests for judges and asset verifications. They were introduced to promote accountability and transparency. Over the time, civil society's active involvement was complemented by international experts participating in selection procedures. And key institutions like the High Anti-Corruption Court, the High Qualification Commission of Judges, the High Council of Justice, and even the Constitutional Court of Ukraine were established with international, not established, but the judges were appointed with international expert involvement to ensure integrity, professionalism, and transparency in their operations. And do you think that it might help with this, so to speak, involvement of the international experts, which caused lots of discussions on national level, because some lawyers and practitioners, they considered it as interfering into sovereignty of the state. So can it bring any changes to the matter of trust and confidence in the judiciary, the participants of international experts who take direct part in selection process?
In selection of judges or selection
Yes, selection of judges and judicial institutions such as High Qualification Commission and High Council of Judiciary.
I think I find that a difficult question to answer because so much depends on the particular country. We're talking about Ukraine, which I know a bit, but not very well. And I can see the constitutional objection, the quasi-colonial feeling that that other countries are coming who know better, and there's something sort of less developed and less about Ukraine, which other countries can improve on. On the other hand, a number of places in near Ukraine to the east of Ukraine have got foreign judges sitting in their courts. Kazakhstan has an international commercial court, which is mostly retired English judges. A number of the Gulf states have courts which are manned by English and other former judges. Singapore has a commercial court and court of appeal, which has a number of different foreign judges sitting and ex-judges, foreign ex-judges sitting in court. And Hong Kong has the foreign member in the sitting in the Court of Final Appeal. To that extent, those countries clearly think having experienced, respected former judges sitting in their courts is a good thing. You're asking a slightly different question, which is involving foreign judges, ex-judges in the selection process. And that's why I'm slightly cautious, because I think it depends on internally, it depends on how that would be perceived. And I don't feel confident to talk about that. Externally, it must give some confidence. In other countries, for instance, if one's looking towards the EU, it must be right that if you've got respected former judges from EU member states helping select and monitor your judges, that would be a sign of taking judicial independence and judicial integrity very seriously. But as I say, I'm slightly nervous about expressing a view about the internal effects because so much would depend on the individual country. I'd like to think that people would see it as beneficial. I also think that for judges of any one country to see experienced, respected ex-judges from other countries in action, working with them, must be good for them. I think one thing that we would benefit from in this country, in the UK, would be a few more foreign judges, experienced judges, ex-judges coming here. And one of the advantages we have as the UK is we do have separate judiciaries in England and Wales, in Scotland and in Northern Ireland. And I think the different experiences, even though we're all part of the same country, are good. And having had a history of what you might call former colonial court, the Privy Council, which takes appeals still from a number of island states which were part of the or are part of the Commonwealth. I think that enables us occasionally to have judges from those countries sitting with UK judges, which is beneficial for the UK judges. Cross-fertilization, in other words, I think is a valuable thing and should give people confidence, more confidence in the system. But as I say, each country has to be judged on its own culture and traditions.
Actually, I was going to ask you and to move to this topic of involvement of foreign judges into domestic courts and sitting together to resolve investment disputes or war crimes, because again, it's all about trust. For example, criminal charges in Ukraine, considering the war crimes, raise the question of impartiality on obvious reasons, of course. And, you've been involved in presentation of the Bickel report concerning unlocking investment in Ukraine, and we've been discussing different possibilities for involvement foreign judges into domestic courts to resolve investment disputes. So obviously you think that it would be an adequate measures to support, so to speak, transitional justice in Ukraine after the war, probably.
Yeah, I think it would be a good thing. I think, as I say, in terms of selling it to the public, if it needs to be sold, you can perfectly validly make the point that it's not just Ukraine that's doing this. It is something that's done by other countries, and it does give them an advantage. I think you're absolutely right. There are lots of cases that depend on understanding the culture of the country or the how things work and understanding domestic legislation, which may make it difficult to involve judges on those sort of foreign judges on those sort of cases. But things that involve international law or commercial law,
Mhm.
and I mean, you may even want to have a commercial court that applies the common law or give that as an option. I don't know. But obviously, if you do, it helps to have common law judges. But it does, as I say, sitting as I do in Hong Kong and Singapore, it's not simply me saying, look how beneficial it is for Hong Kong and Singapore to have me as a judge. I hope I had something, but I also learned something by sitting with judges in jurisdictions who I wouldn't have sat with. I think it is very beneficial for judges to sit with judges in other jurisdictions, learning things and processes and traditions that maybe they hadn't thought about.
Absolutely, and it helps to open your mind as a judge, and it is
Yes,
crucial for a judge to be open-minded all the time and to learn all the time. Moving
absolutely right. Yes. But
and
we talk about diversity, but
yeah.
it's a very broad concept and it includes diversity of experience, diversity of thought. And I entirely agree.
Absolutely. And moving to broader implications beyond Ukraine, trust in the judiciary is fundamental to democratic governance globally, and the risks posed by Political interference, as we said, or weaponization of courts may have destructive consequences for democracy and society in the long-term perspective. I would like to refer to your speech, which was given at the farewell sitting of the Court of Final Appeal for Chief Justice Joe Ma Tao Li in 2021. You said, "This is a particularly demanding and important task in Hong Kong, where there has been much political change over the past 25 years and where many sections of the media and some public figures on both sides of the debate do not hold back from criticizing the judiciary in very blunt terms." And I can say that it would be fair to say absolutely the same, word by word, for Ukrainian reality and for many other new European democracies, I mean, Eastern European countries, post-Soviet space. And what the question is maybe naive, but what can we do to, as a current and former judges, to address the challenge of populism and uphold the trust in the judiciary, considering our limited freedom of expression? We all know about our limitations. And I would like to add only that recently I read an article of one of the judges of the Supreme Court, who is a speaker judge, and it is a huge academic discussion in Ukraine as well. So the author of the article, Konstantin Vilkov, he considered public opinions of a judge in defense of the rule of law, the transformation of the right to freedom of expression into an ethical and legal duty to speak out in defense of fundamental values. So where are these limits to defense the judiciary, the high standards, as you said, of judiciary, democracy and the rule of law, when judge is taking the floor? And
I think it's a big difficulty and was very well analyzed by the famous Alexander Hamilton in one of his Federalist papers, where he said that of the three arms of government, the judiciary is the weakest. It has neither purse nor sword at its command, and in the end, it has to lead simply by example and by principle, applying principles. I'm not sure how valuable it is for judges to speak out more than they do. I think we're great believers in the power of words and the power of logic and the power of principle, which we always tend to follow or try to follow. But outside the legal world, outside the courts, I think things are more atavistic, less logical, less comfortable. And the difficulty with judges getting involved in debates with populist politicians is that they risk devaluing the coinage. Their job ultimately is to sit in court and give judgments and decisions which speak for themselves. If they start getting involved in politics, then, as I fear one seeing in the United States, you start devaluing their apparent independence, even if they're very careful and speak up in terms that indicate no particular political bias or prejudice and simply sticking to the limited non-political party issues of the rule of law and human rights. They will still be branded as being political. They still stepped outside the courts and got into the political arena in speaking in public. And I think that will devalue their effect as judges. Judges do have a duty to speak out, but I think it's a duty which must be exercised with great caution. I always took the view when I was a judge in the UK that it was only really probably the 3 or 4 senior judges in the UK who should speak out on anything sensitive. Once you say judges generally should speak out, you'll get different judges speaking out at different times in different ways. Some of them undoubtedly will go further than they should. And the whole judiciary's independence and relative detachment will become severely damaged reputationally. And I think one has to be very careful because, having said that, there are undoubtedly occasions where it's the duty of the Chief Judge, the Lord Chief Justice or Lady Chief Justice in this country, President of the Supreme Court, to speak out about something. But it has to be very rare, in my view. Fine to speak out about the rule of law, generally, the importance of human rights, the use of technology and AI in the judicial system, that's all fine. But if you start focusing on particular issues which are politically sensitive or high contemporary importance and possibly the subject of feverish debate, then I think the judges severely risk losing the reputation which they otherwise should have. It's not a perfect world. There are, however good your judicial system, there will be countries where horrible things happen despite good judges. And even if you've got it, because that's human nature, that's history. And the danger of fighting for perfection is that you ruin the system out with the best of intentions. So I'm a bit cautious about judges speaking out too much.
Thank you for your opinion, David, and thank you for your honest and high professional answers to the questions of this interview. Finalizing, I would like to say that we are approaching to a very sad date, 3 years of full-scale war, which is existential war for Ukraine. And the resilience and capacity of all the state institutions are very impressive. And I hope that our today's discussion is contributing to this capacity of the state institutions and judiciary and Ukraine as such to face this challenging time and to survive. So thank you so much for accepting the invitation for this interview. We do appreciate very much. And looking forward to our next conversations and interesting discussions.
Thank you
you.
very much. Thank you for your questions. Interesting questions. And as you say, a very challenging time for the institutions and people of Ukraine. And I hope they come through it successfully as they deserve.
Thank you. Thank you.